Barbara McQuaid is standing by. I want to get to her. I'm sorry for cutting you off, Andrew. Barb, we've been talking about this for many hours now. You're a fresh face, fresh voice. Give us your insights.
Yeah, so I thought Michael Cohen did very well on his direct examination, but as you have been commenting, he's far too defensive, it seems to me, on cross-examination. When you're caught in a lie, fess up, you're under oath. Yes, I lied, I did it for Donald Trump, whatever is the case. Because I think those are the kinds of things that can make him look less credible in the eyes of the jury. And although the prosecution did a very good job of laying the groundwork leading up to his testimony, to plant the seeds, to use corroboration in the form of emails and text messages, I think they really do need to believe Michael Cohen to be able to conclude that Donald Trump himself was personally involved here. And so, typically on cross-examination, there are two schools of thought. One is, I'm just going to make a couple key points. I'm going to get in, I'm going to get out, and I'm going to sit down. The other is, I am going to wear this witness down. I am going to expose him. I'm going to make him lose his cool. And it seems to be that latter strategy that Todd Blanche is following here. So we were going to see a couple of days of this. And I think the jury is going to see the true colors of Michael Cohen. And I think, he's someone who lies. He's lied consistently throughout his life. And so now is his opportunity to own up to that. And I think all of the hedging does not do him well or the government.
They're talking to him now about truth versus not truth. And he's saying things like, I was trying to be protective. I was trying to be loyal. Is that something a juror will understand?
Oh, I think so. I think, there's it's probably the true story here, which is there was a time I was very loyal to Donald Trump and I was willing to lie for him. I would take a bullet for him. I'd go through a wall for him. And that time has ended. And I pleaded guilty to crimes. I took my hit. I took my conviction. And now I'm here under oath to tell you what really happened. And it's all corroborated by other things. But there is something about Michael Cohen that seems to just not be able to help himself. You've got, despite the name, what his podcast, Mea Culpa. Mea Culpa, man. He to say, maybe I said that. It sounds like something I might say. Yeah. I guess you could say that. Just own it. And
but here's the thing.
I agree that.
I think that's, just own it has been the narrative. But what they're trying to prove here is that Michael Cohen did something at the direction of Donald Trump, and the tit for tat, like little ticky-tack lies, or even the big lies. They built up quite a bit of evidence showing that Michael Cohen was talking to Donald Trump surrounding the time that he was making these deals. There are phone records saying they had conversations. There's that snippet of recorded conversation. There's the Alan Weisselberg handwritten notes. There's the David Pecker corroborating the meeting, the Gary Farrow and the documents. There's all this stuff.
The photograph of him at the White House.
So as much as Blanche is going to go after his credibility, how much do you need to destroy his credibility in order to wipe away everything else that we've seen up until this point? Duncan.
You need to obliterate him, because he today said 3 words. He said he approved it. And that is the proverbial nail in the coffin. If the jury credits that he approved it, meaning Donald Trump approved this reimbursement scheme, he's convicted. He's convicted. It's over. The case does not require Michael Cohen. The prosecutor is going to get up and remind the jury that. We don't need Michael Cohen to prove this case, but here's why you should believe him, even though he's a liar. He's a liar. We admit it. But look at how this piece, all the pieces fit together. All of the things you were just saying, look how they fit together. But even if you took him out, the case is proven. But you need to destroy him completely and leave nothing left of him, because if you believe him and you credit his testimony, this case is done.
That's what you were arguing in your op-ed in the Times a couple days ago.
Yep, absolutely. But I totally agree. The defense has to be able to say you cannot convict based on his testimony, and they will then be saying he's critical to the case. So the defenses want to say he's critical. That's why he was called. He's the only one with direct evidence. And would you ever convict anybody based on just his testimony? Of course, the prosecution will say no one's asking you to convict just on that. There's a whole edifice around it.
How crucial are the judge's instructions here, the jury instructions?
Well, I think one aspect will be quite important because, for instance, we've talked a lot about, did he do this for Melania or did he do this for the campaign? And obviously there's a ton of evidence that it's campaign related, but there's some evidence about a concern for Melania. Not a lot, but some. And the judge is going to, in this case. And so the judge is, I think, going to give an instruction saying dual motive is fine. In other words, the state does not have to prove that it's 100% for the campaign.
Who's going to explain the statute? If they're arguing that this is a falsification of documents and they want to bump it up to a felony, what's the underlying crime here? What is that rule?
I'm assuming it's New York election law conspiracy to promote an election by unlawful means.
And the judge.
How come we don't know that at this point?
Well, Josh Steinglass said that earlier, not in front of the jury. This was like a week ago. So I don't know why it wasn't said in opening statements. You typically, in an opening statement, you tell them what the charges are and what you intend to prove. You don't say at the end, surprise, this is it. But I think that's going to be it, the New York election fraud violation.
Can I maybe give a slight, sort of more favorable take to the opening, which is I thought they framed the case based on the facts. And then the law will be given to them by the judge. But they said this case is about two things. First, you're going to hear about election fraud. There's an election fraud conspiracy, and that's sort of the David Pecker conspiracy that was laid out with the first witness. And they said that's this scheme. Then you're going to hear about the cover-up of that scheme. So they really wanted to talk about just what are the facts. We're not going to we'll do with how this, if you put a legal grid on it, we'll do that later. And that's where they will get from the judge all of what is required in order for the state to prove its case.